Welcome to the Roetzel Health Law Hotspot. Health Law Hotspot is a podcast for physicians and health professionals that covers the legal issues and trends that affect the healthcare industry.
Hi, everyone. Welcome to the Health Law Hotspot. I'm Ericka Adler, shareholder and leader of the healthcare practice at Roetzel and Andrews. Today, I'm joined by David Hochman, also shareholder and part of the healthcare practice group, among other groups at Roetzel and Andrews. And today, we're going to talk about a really interesting topic that impacts a variety of different types of transactions that we regularly perform within our healthcare group. And recently, there was a decision, Connelly versus the United States, by the U.S. Supreme Court. And David's going to give us a little bit of a background and a summary of the case and how it impacts some of the transactions and how we draft them going forward. So thanks for coming, David.
No, thanks, Ericka. Small, closely held businesses, professional practices with multiple shareholders almost always have some type of buy-sell arrangements. And the Connelly case involved a small building supply company in St. Louis owned by two brothers. And they had a buy-sell agreement that was actually fairly typical. It gave the surviving shareholder the right to buy a deceased shareholder's shares. And if he declined, then the corporation was obligated to buy the shares. The purchase price was supposed to be determined each year by a certificate of what they call a certificate of agreed value. And if that wasn't in place, then there were supposed to be two appraisals, two third-party appraisals obtained. In this case, to fund the buy-sell agreement, the Connelly brothers bought life insurance, $3.5 million of life insurance in each of their lives. It was owned by the corporation. The brother who owned 77% of the stock died, and the surviving brother agreed with the deceased brother's estate of a purchase price for $3 million. The corporation got $3.5 million, paid $3 million to buy the stock back, kept $500,000 to provide operating capital to the company going forward. The estate filed an estate tax return showing a value of $3 million. They took the position that the $3 million of life insurance proceeds that were received by the corporation were an asset of the corporation, but were offset by the liability to buy the stock. So 3 million minus 3 million is zero. So the only thing to worry about on the estate tax return was $3 million. One thing I think that I was surprised to see is that the estate tax return was filed with the IRS without an independent appraisal of the value of the shares. To me, that is something that was found to be highly unusual when you're paying that kind of dollars for stock. The IRS audited the return and took the position that the value of the corporation included $3.5 million of life insurance. The $3 million was not really a liability. It was just in effect, a reduction in the surplus of the company. So instead of having $3 million of surplus, they now have $3 million of shares that they redeemed. That case that generated almost with interest over $1 million of additional estate tax to the estate of the deceased shareholder. There was an appeal to the Eighth Circuit, which upheld the district court, and then the case was appealed to the Supreme Court, which is pretty unusual because there are relatively few estate tax cases that make it to the Supreme Court. The Supreme Court only looked at really one issue: were the life insurance proceeds an asset offset by the liability to purchase the shares, and they agreed with the lower courts. So we have an unusual result. The Connelly case was contrary to a case that was decided in 2011 called the Blount case, which had upheld the way that the estate had treated the redemption, and that they got $3 million for the stock, and that was the value for estate tax purposes. And what's the takeaway from all of this? the one thing that's sort of unusual in this case is that there were two brothers, and I think that had some impact. I think colored some of the arguments in the case. But I think that the taxpayer, in retrospect, would have been better off had they had appraisals obtained when they did the buy-sell agreement, and had they had a third-party appraisal as an attachment to the estate tax return. So how do you avoid this issue? This occurred because there was a redemption by the corporation. If in fact this was structured as what they call a cross-purchase agreement, where the obligation is for each shareholder to buy the stock of the other shareholder, this issue wouldn't have come up. So restructuring these transactions as a cross-purchase is a way to avoid this. The thing you find that works okay if you have two shareholders, each has a policy on the life of the other. But look at a case when you have four shareholders. Each shareholder has to have a policy on the life of each of three other shareholders. So you have 12 policies. So that is, besides being a nuisance, is very unwieldy. And the planning we've done in that situation is to create a separate partnership or a trust that owns the life insurance policies, one policy on the life of each shareholder. And when a shareholder dies, the policy proceeds are distributed to the individuals who have the obligation to buy the deceased shareholder stock, and they sell the shares. So that's really an effective way to implement a cross-purchase arrangement. It also provides a simple mechanism to make sure that the life insurance premiums are paid on a timely basis. Because if you had 12 policies, consider you're going to have to, if you're one of four shareholders, the last thing you want to do is go and ask the three other shareholders, by the way, did you pay the life insurance premium on that policy you're using to fund my buyout? So it's not really going to happen. The other thing I didn't, which I've never been a big fan of in buy-sell agreements, is the provision that said we're going to have a certificate of agreed value every year. I've seen agreements like that, but I can't recall a situation where I actually saw people actually update the certificate of agreed value every year. And so in this case, they had what the backstop was, they'd have a third-party appraisal.
Right.
So the Connelly case was really a change in what I think most advisors understood the law was in the past. And if you're going to have a policy where there's a corporate redemption that's funded by life insurance, you need to look at how that's structured and make sure that everybody understands what the estate tax consequences are going to be to a deceased shareholder.
Okay, and how did this end up on the radar? It was just they got audited, or how did this come to?
Every estate tax return that is, I don't know how large the estate was. So I think that Michael Connelly, who died in 2013. So I'm, now this case is finally heard 11 years later. Considering it has to go through, it went through the IRS, the district court, the Court of Appeals, and the Supreme Court. That's what accounts for all the time. So my guess is that there was a taxable estate that was due, and every estate tax return that's filed with the IRS is going to be examined by an agent. And I think that one thing that may have piqued the agent's curiosity was the fact how they come up with a valuation of $3 million for the stock. Because how they came up with it, the deceased shareholder's estate and the surviving shareholder reached an agreement. They came up with a number. They could have spun a wheel or thrown darts and come up with a number. So there's no third party determination of how they came up with the value, and that may have been what gave the IRS reviewer the basis to go proceed, or the reason why he thought it's worthwhile going forward.
Okay, so going forward, this gives us a little bit of guidance on what we should be recommending to clients, obviously, as we do their documents. Um, would you go so far as to say that we should consider amending existing documents to address this as well?
Yeah, I mean, I think that in light of this decision, I think that there may be um, some tweaking that needs to be done. If there's no life insurance, the issues are a lot easier. So that a lot of people have buy-sell agreements, but the purchase price is not $3 million and it's funded, the funding is not a problem. Um, I think the issue in my mind is more acute when you have relatives who are the other shareholders. There's more, I think the kind of situation where somebody would say, well, are you really selling the shares for less than fair market value because it's a relative? I think it's worthwhile looking at buy-sell agreements that are funded with life insurance to see if they need to be revised because the economics now have changed. And even if you don't have life insurance, I think that it's a good idea to look at buy-sell agreements to see if the formula still makes sense. We had a situation where practice had been very successful for years and had a buy-sell arrangement that was very rich. And the practice gradually declined in volume and in profitability over the years, but they never revised their agreements.
Okay.
And how this came to a head was one of the doctors in the practice left and said, pay me out based on this formula. And the doctor's partner said, we're not doing that. And there wasn't litigation. They ended up negotiating a price that was between the formula and what the practice probably was really worth. And a few years after that, the practice ended up being sold to a hospital system.
Right. And I think you and I both have seen, some older agreements that, may have a stock purchase price. And more recently, though, instead of just a stock purchase price, which is separate from paying for goodwill or paying for accounts receivable, more and more often I'm just seeing a total valuation of everything. And we're calling that the purchase price for the stock. So, there are changes in trends, and there are additional payments sometimes or additional value included in formulas when you have senior doctors who
Right.
originally founded the practice that are really rich. So there's things that have changed over time, not just economies, but the way documents are being written to reflect the time. So I absolutely agree with you. Well, so there's a lot to think about. So if you're out there and you're putting together a buy-sell agreement, make sure you're talking with your advisors about what we covered today. If you have an existing agreement, consider talking with your advisors about whether it needs to be updated. If you have an agreement that calls for life insurance be maintained and you haven't thought about it since you wrote the agreement, check and see if there's actually any life insurance being maintained. That is a big issue that I come across as well. So any final thoughts?
No, I think having life insurance, there's a lot that goes on in life insurance, just besides the policy premium you pay. You have a cross purchase agreement. How do you know that the person who owns the policy hasn't taken loans out against the cash surrender value of the policy? And what happens if there is a policy loan when the death benefit's payable, a policy loan subtracted from the proceeds the insurance company pays? So in a cross purchase arrangement where each shareholder actually owns a policy on the other, and there's no monitoring of what's going on, there's no way to know that. The other thing to keep in mind is, what do you do with a policy when somebody leaves? You might have a situation where a shareholder leaves and the period of time that he's paid out may run 3 or 4 years, maybe substantial dollars. Does the corporation or the LLC have the right to continue to maintain the policy? Or does the agreement give the departing shareholder the right to buy it from the practice?
Right. And how do
So
we value that? How do you reduce it out
Yeah.
of the purchase price? How
So
does
I
that
think
work?
if you had a buy-sell agreement that has life insurance, one of the things one term you'd want to consider putting in the agreement is if somebody leaves, what rights do they have to get the policy? And what rights does the corporation have to maintain the policy for some period of time after the person leaves? You
Right,
can understand if I've left a practice and I've been gone for 10 years, I'm probably going to think it's strange that my former partners are still maintaining a life insurance policy on me. And hopefully it's not because they're hoping I drop dead. But those are things that people I think don't think about when they see that they conclude that life insurance makes sense because it provides a ready source of liquidity. And
right,
that's a positive. And it enables a group to really compensate somebody adequately for their interest in a practice or a business without crippling the business.
right.
So, but there's more to it than just buying the policy.
Right. Well, there's a lot to consider here. And I think a lot of times people aren't thinking through all these issues when they're doing these documents. Now, just to be clear for everybody listening, does it make any difference as to the type of entity you have when we talk about these kind of issues? Does it make any difference as to the tax selection of your entity when we discuss these kind of issues? Or is it just kind of an across the board issue for everybody to be aware of?
It can make a difference. Um, There are, first of all, life insurance is maintained to fund buy-sell agreements. The premiums are not deductible. So I think that whether it's a corporation or an LLC, tax as a partnership or tax as a corporation, the premiums are not deductible. Um, the one thing you have to look at if you have for example, a redemption, and you want to switch it to a cross purchase arrangement, you have to look at what's called the transfer for value rules. And these are rules basically when you make certain transfers of life insurance policies, it can render the life insurance proceeds taxable in whole or in part. There are a number of exceptions that probably will save the day here, but it's not something that you would want to go and undertake without considering those issues. But you would have that in a corporation. You wouldn't really have that in a partnership. The other thing you might have if you had life insurance where you were making large contributions because you were trying to build up the cash surrender value, there are rules on how much money you can pay in premiums on policies. But the insurance companies and the agents are typically they're attuned to that. And if they're selling large policies that are being loaded up with premiums, they know what what's called the modified endowment contract rules are.
Okay.
So I think the key is this is not something that how hard can it be? It can be really hard because you don't know what you don't know.
Right. And lawyers are great at writing these documents, but you also need to be talking to your accountant, potentially your life insurance agent, etc., like a variety of different people to make sure that everybody is connected and on the same page. So I think it's a great topic. If anybody has any questions, please feel free to reach out to David. He knows way more than I do about this topic and can guide you accordingly. And of course, you can catch all of our other podcasts at ralaw.com. And we look forward to seeing you next time. Thanks for coming, David.
The Roetzel Health Law Hotspot is made available by the firm and its attorneys for educational purposes and to provide general information, not to provide specific legal advice. Use of the Roetzel Health Law Hotspot does not create an attorney-client relationship between you and the firm or any of its attorneys. The Roetzel Health Law Hotspot should not be used as a substitute for competent legal advice, and you should contact an attorney in your state about any legal needs or questions you may have.